Welcome back. You're watching Big Deal, and we are discussing the proposed changes that could be made to the CCI regime and what could be the clarity and the impact of that on the deal street. And we have with us the CCI Chairperson explaining some of the rationale as well as the impact. Now, Mr. Gupta, we were discussing several aspects. Now, the bill also proposes a lower threshold of control. Now, control is a very big aspect, and many different regulators and laws have a different definition of that. How will this particular change in control definition really affect merger control regime in India? And what is the definition of material influence now that you have said? It's a very broad term, and the industry finds it difficult to really understand the scope of it. If you can help us understand with the examples.
See, presently, control includes controlling the affairs or management. Now the bill proposes to define control as meaning the ability to exercise material influence in any manner whatsoever over the management or affairs or strategic commercial decisions. Competition is a highly dynamic activity, and therefore competition law, if it is to fulfill its mandate, has to be equally dynamic. The relationship between the shareholders and investors and enterprises is also fast evolving, and the concept of control, therefore, needs to be one which enables the assessment of such relationship in the proper perspective. Accordingly, it is felt that the concept of control needs to be linked with the ability to influence the strategic commercial decisions, which actually causes the change in market dynamics.
Right. So while you are saying that, Mr. Gupta, one industry concern has always been that, the board composition is done to put those checks and balances on material influence of one particular director. So that is one point of view really coming in. But I'll move on to the other one. The bill proposes to broaden also the scope of anti-competitive agreements and also seeks to include the parties facilitating the anti-competitive horizontal agreements. Now, this expands the ambit of your investigation, and the proposal is targeted at hub and spoke cartels. How will the facilitators be treated in this context, Mr. Gupta?
See, I think there was some disconnect in between.
Right.
But what I feel, first of all, let me explain that there is no change as such in the decision practices of the Commission. We have been interpreting control to mean material control only, ability to exercise material control. So the proposed definition of control in the amendment bill is on the same lines as the CCI's decision practice, and thus does not change the practical parameters being followed. We are not going to change anything. Probably we might be providing more clarity now, and we might be formalizing this interpretation of control. It is expected that the change will make shareholders more aware of their statutory obligations and prevent any unintended non-compliance.
Yes.
The assessment of material control requires a case-by-case analysis of the overall relationship between the acquirer and the target. In making its assessment, we will have regard to all the circumstances of the case. Material influence may arise through factors such as representation on the board of the target, contractually agreed consultation rights, veto rights, voting percentage held by the acquirer. Let me assure the industry that there will not be any change in the decision practice of the Commission, and we are not lowering the threshold in that way.
All right. So that's a big comfort coming in, that you're not lowering the threshold, and it is only defining it. There's no change in your strategy when it comes to control. But what about hub and spoke cartels and the decision to also expand it to the facilitators? Now, that's a very large gamut to really investigate. Can you give us some examples also how it will work?
See, I will again say there was some gap in our competition law. I will explain the situation. The law presently provides that certain horizontal agreements, including cartels, are presumed to have an appreciable adverse effect on competition unless otherwise rebutted. There exist certain unique forms of agreements in which a third party, that is a hub, organizes or facilitates collusion between two or more competitors, that is a spokes. So one entity acts as a hub and there are spokes. In such cartels, the hub communicates with one or more spokes and causes the sharing of information between the spokes. Spokes on their own are not in touch. So that is not cartel among the spokes in real sense. It is through the hub that everything is being done.
Right.
When the spokes are captured within the presumptive rule of appreciable adverse effect on competition, the hub not being in horizontal level with spokes was outside the scope of this presumption. In this backdrop, the bill proposes to expand the scope of cartels to include hub and spoke arrangements implemented by entities involved at different levels of the value chain within the presumptive rule. The bill allows the CCI to proceed against any entity which acts as in facilitating a horizontal agreement or cartel in whatever capacity.
Right.
At present, we are not able to capture certain facilitators of this horizontal cartel.
Right.
I think this will enable us to catch those facilitators also.
Right. So the entire ecosystem. But I will skip to the last question. I had many more, but I want to ask you one overarching question. Do the changes, equip CCI to have better control and regulation over the digital market, which is so dynamic and evolving, Mr. Gupta? Very quickly, we are running out of time.
See, I think our existing dispensation is robust enough to deal with the digital markets. We have been dealing with a number of cases of the digital ecosystem, but now we have got a number of provisions in the existing bill which will further enable us to do this job more efficiently and effectively.
Right. All right, Mr. Gupta, thanks so much for patiently explaining several of those aspects, but this will be open to many discussions, debates after it has been approved by the Parliament, and then probably your guidelines will fine-tune how it really works. But thanks so much for the initial clarity, and we'll wait for the passage of this bill. So those were some important takeaways coming in from the CCI chairperson on the amendments that are proposed to the competition laws. With that, it's a wrap on Big Deal. Thanks so much for tuning in.